and the Church are responsible for and must be accountable for the mother and baby homes and the county homes spoken about in this report and beyond it. And I join in the rejection of any attempts to minimise that. It is, for example, simply not credible or acceptable for the Commission to claim there is no evidence that women were forced to enter mother and baby homes due to the Church or state authorities, when a few pages later we hear of bishops saying the only thing that prevents women from leaving is the strict supervision and boundary walls, when women themselves tell us about incarceration and escape. To describe the awful tone and skewed framing by the Commission as overly legalistic is to give it too much credit. It is not legalistic, it is defensive. More walls, corralling survivors into the confidential committee, squeezing their testimonies into unseen questionnaires, and denying requests for public hearings, even though the actual statutory instrument, which established the Commission, stated that individuals should be able to request privacy, not have secrecy forced upon them. That statutory instrument was from 2015, 1 year after the public duty on human rights and equality came into law. And the report tells us that IREC asked for any investigation to be informed by human rights law, but, and I quote, the government did not opt for that approach in its mandate to the Commission. This raises very serious questions, Minister, and the sidelining of human rights really does show. This report is not the new chapter that we needed, but I hope that it will be the last we hear of the old excuses. A radically different approach has to begin now, and it must be led by the voices, needs, demands, and well-being of survivors. It must offer support, redress and justice, not only for those who endured the 18 institutions in this report, but for the many others affected by a wider systemic architecture of control and abuse right across this island. And we heard again today in Northern Ireland, more parts of that architecture of control, of abuse, targeted at women, targeted at their lives. Minister, I welcome that you took the advice of those of us in this House, and indeed many others, by keeping a copy of all of the files. It is vital that they reach you in unredacted form and that the Commission respect GDPR when they are preparing for the transfer. As was vigorously pointed out in this House by human rights and data protection experts, and crucially by survivors themselves, you will, when you receive these files, become a data controller with responsibility to respond to individuals' requests for their own personal information under Article 15 of GDPR. And it was a relief to see your department's belated acceptance and acknowledgement of that fact. And I am glad that you personally seemed keen to take an open and empowering approach to those requests. It is vital that bodies such as TUSLA also change their responses and their approaches to reflect the newfound understanding of GDPR. And the centering of an individual's right of access to personal information will, I hope, mean a very different approach in the information and tracing legislation you will bring forward later this year. I look forward to engaging with you on that, Minister. And I believe that progress on birth certificates should not need to wait that long. As Data Controller Minister, you may also identify and facilitate other appropriate public interest processing of information from these files. That may include, and probably should include, further investigations into the vaccine trials, financial exploitation, and forced and illegal adoption, because it is very clearly evidenced in the testimony of the women, in other reporting by persons such as journalists in the Examiner and elsewhere, and indeed in other records that we know, falsified records that have been shown, that there is a case and an issue of forced adoption and illegal adoption. And indeed, there was extensive lobbying to avoid the bringing in of proper legal oversight in adoption, and even the report itself reflects that. The apologies at national and at local level are right and necessary, but there are also issues of justice which cannot be forgotten. Those issues of justice, financial justice, justice in terms of adoption, but also justice when it comes to graves and infant death, not just in Tuam, but in Besborough and in so many other places across this country. Crucially, no individual must be asked to give up their legal rights as part of any redress scheme. Redress must be speedy, it must be substantial, it must be centred on the needs of survivors, and it must learn from the mistakes of past schemes. No waivers, no gagging orders, and absolutely no indemnity for religious orders. They must make payment, and we should also examine and re-examine their exemption from capital gains tax when we know that so much property has been disposed of, and indeed when we know that property was so deeply rooted in the discrimination in Irish society. I will finish now, Minister. I know that others wish to speak, but there are wider lessons I would ask you to learn. When the state puts a payment on the heads of vulnerable people, as it still does with direct provision and homelessness, that can be dangerous. When the state surrenders power to religious orders, as currently planned with the National Maternity Hospital, that can be dangerous. I urge you, Minister, to work with all of us to build a state that takes responsibility for the past and responsibility for the future. Thank you.
Thank you, Senator Higgins.